Hello everyone, this is Gilbert Jalad. I'm talking to you here from CPLSPA headquarters downtown, and this is Tufts on Tax, where all your tax law questions are answered here with Mr. T. Scott Tufts. If you have any lawsuits with employers, with employees, with any business, even with the IRS, your questions are answered here, and you can call us at 877-647-7887. Again, 877-647-7887, or you can email him at any time at stufts@cplspa.com. That's stufts@cplspa.com. Now, I want to remind you that Mr. T. Scott Tufts focuses on how tax forms and other issues impact people's daily lives in ways that are often overlooked or unknown. Certain tax forms like Form 1099 and EC, or Form 1099 miscellaneous, or Schedule K-1 or Form 8082 when filed can lead to litigation. Good morning, Scott. How are you? How is everything with you today?
Good to be with you.
Good to be with you too. Now, we have a special topic today. We're going to expand on the K-1.
Yeah, so today we're talking about I am an owner, but I don't have a K-1. The kind of thought process is, how do I know I'm an owner in a business, and how do taxes come into play with that?
Okay.
All right. So as we unpack this for our audience, it's a surprisingly detailed discussion, because as we unpack this, there'll be some things our audience may not fully realize. And this is a reason to get and be very careful in looking at these issues, be on top of them early, and get with the accountants or with someone like myself sooner than later.
So what would be owning a business?
Yeah. So the question becomes, okay, so let's just kind of start with a very simple statement. I own a business.
Okay.
All right. I would say to you, well, how do you know that? So let's take you. So you own a business, Gilbert. How do you know that?
There's nothing to prove that.
How would you prove that you own a business? As simple as that is. Well, so the first thing we want to do is, well, what type of business are we talking about? Because that is where it can start to change.
Okay.
All right. So a sole proprietorship, you wouldn't really have anything with that except maybe a DBA, assumed name certificate, or fictitious name that you're using that you could protect that name and own it personally. So, you could be Gilbert Enterprises, and do business like that. It doesn't have to be incorporated. But if you're using that brand name, then, or Gilbert's Productions, you could do that and then protect that name, and then you could operate as a sole proprietor, and that would end up on your Schedule C of your 1040, and you would not need to go through incorporation under that scenario. But you wouldn't have liability protection because you were not an incorporated structure. So the other options are, well, then you say, wait a minute, I want to be Gilbert Productions, Inc., and so you could form a corporation. You could be Gilbert Productions, LLC. And then if you had other people who wanted to be owners with you, you could be a partnership. And then you can go through a litany of questions about what type of partnership. Maybe you'd want to have limited partners who could only invest and are not involved in the day-to-day management. That could be like a limited partnership or an LLP. Or you could say, no, I want to have a general partnership. If you did that, you could conceivably set up an LLP under our Florida law. And then, like I said, so you've got a menu of options there to choose from. And you would go to an attorney, preferably up front, to make sure you pick the right entity for your situation.
They would come to someone like you.
Yes, absolutely. Right. And you'd want to go through that and pick the right entity based on a lot of different competing issues. But the main thing is to get in our head that let's put tax aside. Your first thing is, what type of business do you want to be? Because then the tax treatment of that entity will also play into that.
So we'll change accordingly.
Exactly.
Okay.
So then the other issue that might come up is some folks have a great idea or a business that is closely held, meaning a personal business, but they envision that their idea may eventually one day attract the market of private equity or publicly traded company. And under that situation, if you're kind of moving down that road or you have visions of that way, you may want to have a corporate structure because you anticipate that. Although it's not impossible to go from an LLC to a corporate structure and then go from private to public, but that's going to play into it as well.
Okay. And then what's the next step?
So
here?
the taxes. So then, but before and as part of the selection of the business type, you would say, well, do I want this business that I have to operate kind of as a standalone taxable entity, which is what we call C corporation, or do you want the consequences to flow through and pay only one tax under the theory that everything would flow through to the owner? So if you think about it, your Schedule C is your sole proprietorship. You report the income and expenses on that Schedule C form. If you elect certain types of pass-through entities like LLC that are flow through, it may end up at the same point. If you own 100% LLC, it might come right back to that same Schedule C. Or if you make what we call an S election, you can have an LLC taxed for tax purposes as an S corporation. Now, if you have more than one owner, almost like a partnership, then the entity might be an LLC, but because you have more than one owner, the default will be a partnership tax treatment. Well, even there, that partnership should issue a K-1 to each of its economic owners, and then it flows through, and that K-1 connects the activities of the entity to your personal tax return. So you hand the K-1 to your accountant and say, here's what I've gotten from the entity to report its activities that flow through to me. So if we're 50-50 in a business partnership LLC, then, and again, this is oversimplification, but 50% of it would show up on a K-1 for me, 50% would show up with you, broken down by type, like ordinary income, the expenses, distributions, and then lots of other information on the K-1. So the point is that if you're in a situation where you're getting these K-1s coming out of your business model, you've got more than one owner, it's coming through to you, or in the S Corp, it's coming to you, then this is what connects the entity with the individual and allows it to flow through. Now, don't get confused. The entity itself will file a tax return, but it won't be paying taxes, at least unless it gets audited. So if you kind of see what's going there. The main thing is that many folks may not realize that an S Corp, that you could be an LLC and make an S corporation election and have it taxed for tax purposes as an S Corp, even though it's an LLC. So that gets people get confused. They say, wait a minute, I thought it was so just remember that the tax treatment can move in a way different than state law, as far as the type of entity.
So because people get confused, so do they need you along the way from the start to the end?
Yes, and
always with them.
And a really strong accountant, because the accountants are in the trenches reporting this. I'm not the one to do the tax returns.
Course,
I know enough about them when they create this litigation.
Yeah.
But I'm not the preparer. So these accountants are critical. They're in the trenches. You get to them early. You don't push things on them the last minute. You give them plenty of time. You solidify these relationships early on. You get a good one. You do some homework. You check on them and make sure that he or she is of a quality that is able to handle the particular type of business you have. So you ask the right questions as a consumer. Hey, have you done returns like this? Have you done returns in this type of industry before? So forth and so on. The other thing you might want to ask also is, are they doing any work for your competitors? Because you might not want the accountant for your competitor doing your returns as well. So keep that in mind.
I see. So that helps a lot. Now we're moving on with our list regarding this topic.
Yeah. So the big thing here is what we're trying to do today is talk about how do you prove ownership? And I think a lot of folks out there, we're trying to get the word out, would maybe run around thinking they're an owner, but they don't realize that there's more to that. So what we want to do today is just unpack how you prove ownership and start to think that through. So if you owned a business and I started to ask you, if you were in business with me and we did an LLC,
okay,
what do you surmise you have to prove that you're a 50% owner with me?
You have to specify that. And
what way?
On the contract.
Okay, so very good. So the Secretary of State's office might have the original incorporation papers, right?
Yeah.
You form the entity and make it
Of course.
official in, let's say, the state of Florida. So the LLC would be there.
Yes.
Do you think that filing with the state and every annual report after that has to disclose who the owners are?
No, it doesn't, I guess.
Exactly. So because it does not have to, it might, but because it doesn't have to, then that's not the only place or even necessarily a good place to look, correct?
Exactly.
Now, do you know what you're called if you're an owner of an LLC?
What do you call?
Members. So it's kind of a kind of simple term, right?
Yeah. Why?
I could be a member of a group. I could be a member of a club, but member means something very important.
Member
in
versus
the LLC.
owner.
Member versus owner, yes.
Oh, okay.
Now, you may use them interchangeable, but you shouldn't. But it might help you say, I don't know this member thing, but I'm an owner, right?
Oh, I see.
But if I go back and say again, how are you prove to me you're an owner, right?
I haven't heard of anyone referring as a member. Like
That's interesting.
now that I think about
That's a
it,
magical
you mentioning it, yeah.
Well, let's do another one. Let's kind of walk this through. If you're an LLC, who is running the show? Who do you think? Who would you look to?
They have to
sign
decide
papers? Who would you, if you walked into an LLC business, Gilbert, you say, I want to see who's in charge. Who would you ask to speak to? What title?
The president, the CEO,
So those are
depending on how
those are corporate terms. Did you know that?
Oh, that's right.
So you might say, I want to see the president and the CEO of an LLC, and it might not mean that that's the person with the absolute legal authority.
Interesting.
Did you know that?
No, actually, I don't.
So in the LLC world, the magical term is manager.
So member and manager
are the key legal terms for LLC.
For LLC.
They go together.
Interesting.
Now, what gets even more confusing is you might be an LLC with those terms, but if you've made an S election and it's treated for tax purposes as a corporation, now which terms are you looking for when you sign the tax return?
Wow, which one?
So if I'm signing, Gilbert Productions LLC, right? And it's made an S election, and you go to sign the return, and it says you're a corporation, and it says, please tell us who the president is. What do you do when you're the manager?
So he would be he would be the president.
And even more confusing is LLCs can delegate from the manager level to that next level and create whatever they want in their operating agreements and create officers at a level below the manager.
Now, not everyone that get into business, like you said earlier, will know all these things, and so
they
definitely
might wing it. They might just use whatever ideas they have.
Would it go through and pass through?
Yeah,
And people
absolutely.
ignore it?
Because LLCs, the whole theory of an LLC was you can do whatever you want if you have a written agreement, sort of, kind of.
Yeah.
But the reality is there's a core concept of entity and terminology, as I'm explaining to you, that folks, if they don't get that down, might need to be sensitive to. So when we were talking a little while ago, you know, and again, not to pick on you, but if you don't know member or manager, then where are you going to be when you're looking at legal consequences of your actions?
If something happens.
Like, let's say in our 50-50 business, and we're an LLC, Gilbert Productions, and I know this, but you don't, and I say I'm the manager. I make myself the manager. You're CEO, and behind your back, I fire you, and I'm the manager. And I am the only manager because I know what I'm doing and you don't, right? I can fire you. I could probably take over the company and box you out and probably keep you from having any say in how the business is being run, even while you're thinking, running around as CEO, that you're equal to me.
Yeah. So you're following the rules. You know the terms. You know everything, and you're following it as on paper legally. And I'm pretending I'm thinking I'm doing the right thing. I have the right title.
Yeah, and so let's say we went through lawyers even, but it was my lawyer, and you just signed the papers. You're like, I trust you, and you sign whatever paper's been put in front of you.
Yeah, that's when you go wrong.
And it's a 25-page operating agreement, and you just signed it. You never looked at the details. But I knew what was in there. I knew that there was officer roles, but they report to a manager, and I make myself the manager. You sign it. And then you see CEO in there and you go, good, I'm a CEO. But you don't know that in this LLC model, it's not quite the same maybe as the corporate model.
With the other party, like your partnership, the way you did it, would you be penalized for being
taking advantage of you?
Taken advantage?
Well,
but you can't prove that, I guess.
No, I'd have
Nobody
you
can
sign
prove that.
something in the agreement that said, you've had plenty of time to look at this and you've had the chance to go see a lawyer on your own, and
wow.
you chose to sign it anyway.
Good Lord, I don't want partners like that.
Well, no, you don't.
Yeah.
But your legal document, you'll be held to a duty to read.
Correct.
And what have we been talking about? How even folks who are moving fast electronically, we click all the time on agreements and agree to 45 pages of agreements because it says, you know, in order to get your app going, you have to agree to the terms.
I know. And how many people read that?
Right. And what happens? You say, I want to negotiate a different deal. You think you'll be able to?
Depends.
Where do you
on
put
what's
on the
written.
phone? Where? How do you do that on the phone? You cross through something?
No, they don't give you a choice.
So our law has something called contracts of adhesion, and that's where you really don't have a negotiating power. You're forced to sign something because it's a one-shot deal.
One option.
And there's a way to challenge that, perhaps, if you don't, you know. So there might be a way to attack some of these situations, but for our purposes, you asked in the very beginning of this, is there an agreement? And absolutely, there should be. Now, Florida allows you to operate with an oral operating agreement.
Wow,
that means we start to draft an agreement. We don't get around to signing it because it's too important to get busy. Then what is our agreement? It's an oral agreement. I'm going to say, well, Gilbert said all along I was in charge.
So there's nothing to prove that.
No, you would say, I never said that. And I'd say, yes, you did. And then you say, no, I didn't. I said, well, it was implied because you saw that I filed things with the Secretary of State that only listed me as the manager.
So if in Florida we allow that, aren't we getting into a lot of lawsuits and problems?
Of course. And there are a lot of them because, and my point of this discussion is to say, not only if you don't dot your I's and cross your T's, but if you don't read that agreement, or you don't have an agreement, you got a problem.
Yeah, definitely.
It's not good business.
Yeah,
and you should read word for word. You read everything beginning to end. You should negotiate from a position of strength. See, if you know these terms and you're informed, then when you go into business, you're not going to make that. You'll be less likely to make that mistake, right?
Definitely.
Right?
That's what we want to do.
And if I present to you a document that says you've read everything and you're going to sign, and it makes me on top of you, right, or puts me ahead of you, we've started off on the wrong foot if we were supposed to be 50-50, correct?
Correct.
So what would that tell you about me in doing business with you?
Not a good
Not a good start.
partnership.
Not a good start to the relationship, correct?
Or partnership. And that's what we're trying to do here in the podcast, to open people's eyes.
Exactly. And so now let's bring it back to the K-1. So we have folks out there who will say, I believe I'm an owner. I believe I'm a partner.
But they have nothing to prove.
They have nothing to prove for it. But here's the thing. Let's say you're bebopping along and you go along, and each year you believe honestly that you're a partner.
Is there anyone that dumb?
Well,
Excuse
wait,
me.
but if you go along and say I'm a partner, right?
Mm-hmm.
But it's one of these LLC things that there's no papers in place. Let's say it's oral, right?
Okay.
Or you haven't seen the operating agreement.
Like what they allow here in Florida.
Right. But you say I'm a partner member.
Mm-hmm.
And you say, well, prove it. You say, well, he orally told me, or she, that I was. I say, oh, so your word against that person? Yes.
Then
how's that going to go? But here's the thing, and the reason for this, for today's topic, we're trying to get the word out that if it's a tax type flow through entity, you have a duty to do something. You're not going to get away with that for one important reason. You've got to say, where's my K-1? Each year. So we're making money this first year in Gilbert Productions. I'm in charge because you signed something you shouldn't have, or you just went along with it. You trust me, and we're going along. Tax time comes along, and all the money we made, we just kept pumping it back into the business. You and I we didn't take a dime out. Well, maybe I did, but you didn't get anything. And we're rolling along, and tax time comes along, and we did okay the first year. You get a K-1 and I get a K-1. You didn't get any money. You have taxes to pay on the net profits of the business, even though you didn't get any money, and you're not getting any money to help pay those taxes.
And
how
get
does that
money.
feel? How does that feel?
Feels terrible.
Right. So you'd want to negotiate for a salary, which in the LLC world, in partnerships, they call a guaranteed payment. You'd say, I want money to pay my taxes. Correct? Because it's not like an employee situation where you withhold, right? We talked about that last time, the W-2, W-4, and all that. So if you're running around and you say you are something, our message today is you need to get the tax form that equates to that title, and that you cannot bury your head in the sand and sit around and do nothing. You can't sit there and go, I'm an independent contractor, while getting a W-2. Or you can't be a employee, right, and get a 1099. You can't be a partner and not get a K-1. You can't be a partner who doesn't get a K-1 and sit there. You got to file an 808 too. So the bottom line with everything here is you cannot sit there and bury your head in the sand. You've got to each year assess who you are, and are the tax forms corroborating that status. Does that make sense?
Definitely, that definitely makes sense. And you definitely need a lawyer with you. If you're not getting into that and you're not checking it, you need someone to check it legally and make sure.
Yeah, because things aren't always the proverbial black and white, because it may be gray.
Yeah.
So, for example, Gilbert, what happens if I have something that is a restricted interest of some kind that is not clear on whether and what it is? Meaning, like, what happens if it's a prospective interest? What happens if it's a, it gets confusing. Under Florida law, you can have a membership interest, but not have it be economic. Meaning you could be a member without an economic interest. So the tax law might not treat that as a valid partner, but you would absolutely have a legal standing in the voting, right? So the different possibilities here are infinite. what we want to say is, and then things are gray, right? Like we were talking about, well, I'm an owner. Well, what does that mean? Are you a member? Are you something other than a member that's been adopted by the company as a way to proceed, right? Like, we're going to call it something different. The whole premise of LLCs, and we'll finish with this, the whole premise of like an LLC was we want to do like, we want to help with metrics and inches, right? So remember when you had inches and then they went to metrics because it's going to be more worldly and global. LLCs were, we want a flexible entity that draws the best of partnerships and corporations, right? And and allows you to have the flexibility of using either terms. Well, what happened is the corporation had been around a long time with all the law in place. And here comes the LLC with its flexibility. But even in our example, when you were saying I'm CEO, I said, okay. But that didn't mean the same thing under the LLC law than it does corporate law necessarily, right? So do you know enough to protect yourself? Do you know enough to, And so Gilbert, and then with labels and terms, they mean something. So I hope by today's podcast, our audience can say, wow, there's titles, there's terms, there's agreements, there's things that must get put in place. They must be done carefully. And then the next stage is tax may go in a different direction. We better get our accountants and lawyers lined up and make sure we're protecting this stuff. And then last but not least, you cannot bury your head in the sand. Wait for this to hit one day. You've got to be proactive each year because you need your tax treatment to corroborate what you think you are. How did I do?
Absolutely great. And you heard it, folks. Don't bury your head in the sand. This is the key phrase right here. And be on top of it. Make sure to ask the right questions and hire the right lawyer, someone like T. Scott Tufts, who will help you from the beginning to the end to make sure you're not in trouble.
So the big thing as we conclude today on the topic is that if you believe you're an owner or member or person in a business, then now's the time to say, I didn't get a K-1, I need a K-1, request a K-1. If you don't get a K-1, you got to file the 808-2. Talk to your accountants. Do not let this just wait around till the deadline of filing or the extended deadline. You have to be proactive. The instructions say that you need to try and fix these issues now. So that's another reason to get the word out now,
exactly,
rather than wait till April 15th or an extended.
Now we're on the tax season, and if we're
rocking and rolling, right?
Yes, yeah. Take care of this before it's too late, right?
Exactly.
Okay, folks, if you have any questions or if you need T. Scott Tufts for any help regarding the K-1 or anything else regarding tax laws, you can call him at 877-647-7887. Again, that's 877-647-7887. Or you can email him at stufts@cplspa.com. That's stufts@cplspa.com. Or you can visit our website at cplspa.com and you'll get more information, and we'll be more than happy to help you. Thank you, and we'll see you next time with another new episode.